there's two bills which are problematic, one more problematic than the other. The first being the Political Parties and Organizations Amendment Bill, where they are seeking to force political parties to sit and have negotiations and discussions and that kind of thing. It's problematic. It's hinged on the funding that political parties that have representation in Parliament get, that's passed by Parliament. And so the mover of the bill, or whoever sent her to move that bill, to propose and promote this bill, is saying parties that are not part of the National Consultative Forum will not receive funding that is passed by Parliament. That's interesting, because National Consultative Forum is a creature of law. I know for a fact that the target has been, especially NUP, that decided to stay away from iPod. And we did give our reasons, but NUP is part of the National Consultative Forum. In fact, we are the vice chairs of the National Consultative Forum, because legally the party in government chairs, then the leading opposition party seconds and nominates the vice chairperson. And previously, the vice chairperson we had nominated as a party was Honorable Jolly Mugisha. When she passed on, we nominated Councillor Benjamin Katana, who is the vice chairperson of the National Consultative Forum. As opposed to trying to force parties, you see it, let's talk by force and so on. You show goodwill by doing what is right. Our concern has always been the persecution. Stop persecuting us as leaders in the opposition and our supporters. Release all political prisoners. Let us as political parties, all the different political parties, especially those in the opposition, let them be able to go out there, do mobilization the same way NRM does and so on. That way, you just might entice us to say, okay, you want us to sit on a round table, let's sit. Because there's goodwill out there. But it doesn't make sense for you to say, let's sit, talk, have a cup of tea, take pictures and so on. But tomorrow when we say we are going to Arua for mobilization activity, police and the military will be waiting for us to foil our activities. So those are the things that need to be worked on. Otherwise, don't think you can force people to say, you sit in this room and talk by force. By the way, you could even force them to enter the room. But you're not going to force them to speak, to have genuine negotiations. But, we have agreed this morning as the Joint Opposition Caucus that while we do hear all those different views, it's important that we use the platform that we do have, the legally provided for platform that we do have, to push back. Is it going to be easy? Certainly not. But it's a platform that we must be able to use, that we get to be on record. It's important. It doesn't necessarily mean that we shall win. We could win, by the way, but it's not guaranteed. But it's important that we get to have our say on record, so that tomorrow we even have a basis for challenging whatever we would like to challenge. If we choose to go to court, for example, assuming we choose to go to court, because there's several grounds anyway that we can rely on, we shall need a basis, having been present, having had our say on record, and then you use that to challenge, whether it be in court or whatever else. But also importantly, we should not, even with all the challenges that are thrown at us, we should not give up easily. And we'd like to appreciate the people of Uganda who are very resilient. They have been boxed in a corner, they have been persecuted, but they don't stop. And we encourage them to keep fighting. You've heard some people saying, you who talk on Twitter, on social media and so on, when you talk, what value does it add? We think that it adds value, and that's why we encourage Ugandans, don't keep quiet. No one should tell you don't use that platform, that when you speak on social media, nothing changes. No, it adds value in the grand scheme of things. So don't stop tweeting, don't stop speaking on social media, use those platforms. And it's the same thing we are saying as members of Parliament. Let's use the platform that we have also to push back. The ruling was unequivocally clear. Civilians, the military courts don't have jurisdiction to try, not just civilians, by the way. It said even military persons, if they have committed an offense that is triable by the High Court, the military courts don't have jurisdiction to try those offenses. whether it is a civilian or a soldier. The exceptional circumstances which people are trying to clutch onto is if there is an offense that is not provided for in our Penal Code, our Penal Code Act. An offense that was not envisaged. But that's not the case, because all the offenses which the military court has been trying are triable by the High Court because they are provided for. So that should not be an excuse. I elaborate further on the 100 million shillings. I don't know what further elaboration, because we have stated all there is regarding this matter. That this was a bribe to members of parliament. It was wrong. And that's why it was given to them in the middle of the night, not through the channels through which members of parliament always receive money. You remember, even previously during Tojikwata Court, 29 million shillings was given to members, apparently to go and consult their voters. The opposition at the time and its leadership sat and said this is wrong money, even though, by the way, it was channeled through their accounts. They went and withdrew it, and they handed it back to parliament. But this time round, no, it was not even channeled through our accounts. Members were going stealthily in the middle of the night, wearing hoodies, some entering here parliament, others entering homes, stealthily receiving this money. That was the problem with it. And since then, some have come out to admit. I wrote to the Inspector General of Government over this matter, asking her to investigate, because there's overwhelming evidence, including some members who have acknowledged that for them they received the money. The IGG has not gotten back to me. I'm going to remind her, just in case she's forgetful, or that she became too busy and did not attend to that matter that I wrote to her about. Because our house is a house of record, and that's why we always get disappointed whenever the Speaker pretends that she doesn't know who has invaded the House to chase away journalists and to beat up members and so on and so forth. Because when we put it to her the other time, she said, even me, I don't know. I said, really? That's pretentious, of course. It's a house of debate, and so we are not going there to use manpower. We are going there tomorrow to use brain power. That's what we are going for, and that's why there's a dress code which is prescribed. We come clad in suits. If they wanted us to come to fight, they would tell us in advance, wear track suits or trainers or whatever. So we are coming to deliberate. It's just that, of course, when we overpower them with the brain power, they choose to use manpower and violence, because that's what they have. But we are coming to push through our views and thoughts based on the law.